Welcome back. You're watching HFO-TV. HFO-TV is co-sponsored by the construction, repair, and restoration firm J.R. Johnson, the real estate law firm Baljanik LLP, the tax deferral accommodator Butler Exchange Group, the mortgage banking firm Gantry Incorporated, and forensic building consultants providing building structural science services.
Welcome back to HFO-TV. I'm Greg Frick, partner at HFO Investment Real Estate. Today we have with us Brad Kraus, attorney at Warren Allen. Brad's been with us multiple times through the years talking about some of the kind of the laws in the landlord-tenant arena. So I know there's been sessions in both Oregon and Washington, legislative-wise, and Olympia and Salem. We thought we'd bring Brad in here, close to the end of April, and talk about some of the bills that are, again, not signed yet by the governors, but they're on their desk, so in all likelihood they'll go through. So, Brad, thanks again for taking the time to do this. I know you've been very busy and very generous with your time with our audience.
Thanks for having me. It's crazy times we live in, and obviously the landlord-tenant world is ever changing, and it seems like it changes every month. And here we are again.
Yes. Well, why don't we start with the state of Washington first? They seem to be a little bit further ahead in getting things through their House and Senate than where kind of Oregon is. So let's maybe jump into some of these, House bills that are, on the governor's desk, so to speak, and maybe shine some light on what those look like and what pending changes for people that own property in the state of Washington.
Sure, and just to be clear, these are so new. They just passed both chambers of the legislature relatively recently. So I've literally gone through them probably once or twice only and started to create sort of the lecture handouts for them.
So we'll just do a higher level thing, and it's for people in the audience, as he's got the ability to go through, we'll have resources on our website. You can get to Brad's website below and kind of get an idea of, give us time to go through these. But we thought with the newness of them, it'd be so great to kind of give everybody that, 30,000 foot view as to really what may be pending here very soon.
So Senate Bill 5160 is one of the big ones in Washington right now, and that a lot of that deals with tenant protections related to the situation, non-payment and COVID and things like that. Section 3 of that bill kind of leads off with tenant protection. A couple of the big highlights from that, no late fees for the non-payment of rent and 6 months following the expiration of the eviction moratorium. So that's one of the big piece. No reporting of those amounts to prospective landlords either. So if there's COVID amounts, you can't report those to prospective landlords. Let's say your tenant moved out and they had a balance. Looks like you can't report those.
Now, Brad, could you report that to a credit agency?
No.
Okay.
So can't report those or any unlawful detainers that resulted from those amounts. You also can't report those, and the prospective landlord can't take adverse action on those. And so those are a couple of the big ticket items on that front. The prospective landlords also can't deny or discourage applications based on medical history that's clearly related to COVID. And I wouldn't have clients do that anyway. That would be a problem.
Right. That'd be kind of that's a slippery slope to go there.
Can't even inquire about it unless you're evaluating a reasonable accommodation under the Fair Housing Act. And the penalty for doing that is 2.5 times the monthly rent of the real property at issue. So they clearly tie it to whatever the rent for that property is that the person would be applying for.
Okay.
So that's what they tie the damages to there. So that's couple of the big ticket items from the tenant protection side of things. The other big thing in 5160 is it expressly details that the eviction moratorium is to end on June 30th. That is expressly in 5160. It's interesting because I've heard some folks from the legislature say, well, that doesn't stop Inslee from doing something down the road, which I'm kind of confused as to that. Why would you put it in a law if you're just going to defer it?
Executive order it further on or something.
At a certain point here, the legislature needs to stop deferring to the executive, and we need to have 3 co-equal branches of government instead of just one. But that's a different discussion.
No, and Brad, none of these are tied to the federal, if this federal CDC came out and did, extended it out, would that give, who knows, give the states the ability to, oh, they extended it out, we're going to extend too?
Well, keep in mind that obviously right now, so all of this right now, this 5160, Inslee's proclamation still goes until June 30th.
Gotcha.
So
Okay.
it's not as if any of this 5160 or what we'll talk about after this 1236, House Bill 1236, Inslee's proclamation is still in place until June 30th. So that's still what we're working with up until then. So
that oversees everything.
Yep.
Right.
So Section 4 of 5160 is another big one with regard to repayment plans, and effectively it requires the landlord to offer a reasonable schedule for repayment of the unpaid rent that accumulated during the sort of the moratorium. But those payments can't exceed an amount equal to 1/3 of the monthly rental charges for the accrued rent. So it really seems as if the legislature is wanting to provide tenants a very, very extended period of time, and you can probably extrapolate how this is going to be. I mean, 2-3 years down the line.
So the repayment plan can only be equal to 1/3 of the monthly rent on a monthly basis.
That's the way I read it. And again, we're still reading through these,
Okay.
still trying to figure this out, but that's pretty much the way that I read it. If the tenant doesn't accept that offer within 14 days of the landlord's offer, then the landlord can proceed with a UD type filing again, as long as they're consistent with the ERP requirements. And the eviction resolution requirements is another thing that's in these bills, which I'll talk about in a second.
And again, a landlord can't report that, a property owner can't report that to another property owner, so to speak.
Yes, so that's tying into that first part. But if the tenant defaults on any payments in that repayment plan, then the landlord can do one of two things. They can either apply for the landlord mitigation fund, which a lot of Senate Bill 5160 deals with the landlord mitigation fund. It sounds like maybe there's some more money in there. There's going to be some more money in there for landlords. So I would encourage landlords with pretty high balances, or tenants with pretty high balances, to look into the landlord mitigation fund, because it does sound like there's going to be more money in there. So they can either apply for that, or two, they can file a UD subject to obviously the eviction resolution program. So that's a couple of things. The big thing there, and the problem that we're now facing, is that it's a defense to an eviction if the landlord doesn't offer a repayment plan that's in conformity with this section. So the concerning thing that we're dealing with right now is a lot of landlords, a lot of my clients included, have been, working through the ERP process in good faith, reaching agreements with tenants, and now we've got 5160. So what we're trying to do now is we're trying to figure out how all of this stuff works together. And I meet with folks, sort of the players at the Clark County level with regard to the eviction resolution program. We do that every Thursday. It's landlords advocates, tenants advocates, and then one of the judges involved there. I'm going to try and figure out kind of the collective consensus of the group with regard to some of these ERP processes that have already happened, because it's really concerning when everybody's engaging in this in good faith, and then the rug kind of gets pulled out from under us. Right. Landlords are kind of used to that at this point, I guess, and that's the unfortunate thing. Couple other things with regard to 5160. The eviction resolution program is now going to be a thing. It's going to be a concrete thing, and the notices, it looks like they need to contain certain disclosures. We'll have some updates on those in terms of forms as we get them together. I haven't had a chance to update my forms yet since this is so new, but we'll update those and get the forms out. The other big thing with 5160 is there's now a right to counsel. So tenants will have a right to counsel, and that will attach. My understanding is that attaches at summons and complaint. And how they're going to fund that, or how they're going to come up with the amount of bodies that are necessary to do that, unclear to me. Some of the players that we've been talking with within the ERP program are on the tenant side of things, legal aid, and the Housing Justice Project, Clark County Volunteer Lawyers Program. they're even concerned about how they're going to manage this. There's just not enough bodies. There's not enough attorneys.
The sheer volume of that, yes.
I frankly, I don't understand how the legislature thinks that's feasible. And this utopian world that they seem to live in, where there's hundreds of thousands of lawyers just, waiting around trying to, waiting to help with this. It's just not the way things work. But I digress on that. It's a separate discussion. Again, right to counsel is now a thing. It was a thing, I believe, up towards Seattle.
So on a right of counsel, from an issue from like a property owner in your standpoint, I mean, if that's the case, and they don't have the resources to do that, that's just going to delay all the proceedings, so to speak.
Yeah, that's the real concern is, there was discussion about delaying or basically extending the eviction moratorium, because some of the folks with regard to the Clark County Volunteer Lawyers Program, the Housing Justice Project, they obviously understand that they need to hire more people to help with all of their new jobs that they're going to have to do pursuant to these laws. And the funding might not be there in time because all of this stuff is being allocated, and their concern is we're just not going to have the funding. So those discussions right now in terms of how that's all going to play out are still ongoing. But again, the main thing to take away there is the right to counsel. Tenants are going to have the right to counsel in an eviction setting, and that does attach at summons and complaint, from my understanding. But even in the eviction resolution program, that was contemplated therein, and so really unclear how all this stuff is going to play out, or how they're even going to manage it. But that's
kind of par for the course. I mean, we've kind of seen that with a lot of the legislation that's passed in both these states. They've kind of put it down without kind of thinking about the players involved, and on both sides, property owner sides and tenant side, is it even workable? So
obviously there's a bunch more within 5160. It's a 33-page bill, but those are kind of the big ticket items that I took away. Moving on to House Bill 1236. This one really deals more with terminations and no causes. Washington is going to move a little bit more towards what Oregon is, which is kind of that perpetual sort of tenancy after that first year of occupancy, that first year of the rental agreement. So basically kind of the higher level view of things, a landlord can evict or refuse to continue a tenancy or end a periodic tenancy except for cause after kind of that first year.
So after that first year lease, you are obligated to, assuming that there's no cause issues, you're obligated either to do another lease or they're going month to month.
Yeah, so we'll talk about the causes in a little bit here, because some of they have updated some of the causes to help landlords a little bit. There is some help in there, and I'll talk about that in a second. But if the landlord and the tenant enter into a rental agreement that's month to month or periodic, after the agreement expires, the landlord cannot terminate except for cause. But they can terminate at the end of that initial period of the rental agreement. So it's that kind of that first year, that first period. If the rental agreement is 6 to 12 months long and the landlord gives 60 days notice. So that kind of that first block of time, that first periodic tenancy, 60 days notice you can do. After that, again, you're going to be into that perpetual tenancy type situation.
So do you think you'll see less 12-month leases then? I mean, what do you advise your clients on something like that?
I think 12 months is going to be the limit on that. I think it's going to fall in kind of a system like you have in Oregon, where in Oregon, if you have a lease that's longer than 12 months, you're already in a situation there where it automatically rolls into a month to month. So it's I think 12 months is going to be the limit there, and again, that's what I advise clients in Oregon too. So
would you advise doing a lease of like 11 months and then give you the ability, if hopefully the tenant's great, but if not, then you've got some maneuverability to not continue the tenancy?
Well, it's a matter of when you figure out that you're going to terminate, because when you're in that first year in Washington, if you give that 60 days at the end, you can non-renew. You can say, hey, I'm not extending your tenancy. those rental agreements can also automatically expire by their terms. So that's a piece in Washington too that they sort of touch on there. So I think that the maximum is 12 months, and then after that, kind of goes from there. So
Okay.
there's a lot. The causes of termination have now been a bit expanded. They're kind of the things that you would think. Non-payment obviously is one of them. Couple of big items that they did add that are beneficial to landlords. They updated the 3-day sort of waste nuisance portion of the statute. And so it's 3 days for waste or nuisance. And then it says, or other substantial or repeated and unreasonable interference with the use and enjoyment of the premises by the landlord or neighbors of the tenant. So our biggest problem with Washington law for the longest time is that Washington law never had a repeat violation notice. Oregon,
Right.
take a look at Oregon, we have a for-cause notice, and then if the tenant commits substantially the same conduct after that within 6 months, you can serve them a repeat violation notice, and there's no cure for that. This edition here, I think we're getting there. I think that's something that we can use where, if you're having a repeat violation, you're having sort of that same type of conduct, maybe tenants partying nonstop, right? Well, before we would serve them a 10-day for your partying, say don't party. Well, if they stop partying for 10 days, then technically they've cured that 10-day, right? It's a comply or
So
quit.
then every time you're starting over again and again.
Exactly. And we always thought, well, if they do it more times, could we argue, well, technically you haven't cured this notice because you keep doing it. Well, now we've got something that we can tie on to. So that's really good. The other thing that they've added in is now there's what I'll call a 4 strikes notice. And the interesting thing about this is if you take a look at Oregon's statute, 90.427, Oregon has kind of the 3 strikes approach where you can non-renew a lease for 3 strikes.
Right.
And in Washington, it's 4 strikes. And the language that they have is basically pulled from Oregon statute, and it's basically just placed into Washington. It almost mirrors each other. It's kind of, you can tell it's intentional.
Other than they added one more strike.
You have
Added one more strike. You have to serve a notice, with every sort of warning or strike, so to speak. It has to describe the violation, and your notices have to contain specific disclosures in order to qualify for that. So we'll be updating forms and the like, but again,
Okay.
the 4 strikes within the preceding 12 months is a new piece. So that's good. So that's beneficial for landlords there. Those are a couple of the big takeaways there on that one.
So again, it sounds as if they're going mimicking a little bit of what we see in Oregon in terms of some of the statutes, again, having, at least now we've got a strike statute, the tenancy thing. And again, people, we're going to have more information on this. Brad's got a chance to kind of dig deeper in this. This literally just happened this week. Again, Governor Inslee's kind of proclamation on top of this kind of supersedes all this. So this probably is all coming in place if things stay the same, starting probably July 1.
Yep. A lot of this stuff is, again, it doesn't really matter until July 1 because Inslee's proclamation kind of oversees everything and or overarches everything, I should say. And then once July 1st rolls around, obviously then these new rules will kick in unless Inslee decides to do something else, which I don't even know what we're doing at that point anymore.
Right.
So then let's talk a little bit about Oregon. I mean, Oregon had some bills on the, down on the docket down there. I know some got through, some didn't. I don't, kind of maybe show a high level on some of those that you're kind of watching and maybe concerns, or if there's any out there that, maybe look promising from a property owner standpoint.
Yeah, so Senate Bill 282 is the big one.
Right.
That's the one that's kind of making its way through right now. It does look like it's going to pass. Senate Bill 282, the big item there is it's going to extend the grace period through February 28th of 2022. So if there's unpaid amounts due to COVID, that grace period is going to be extended pursuant to Senate Bill 282. So that's unfortunate, because it's going to prevent landlords from pursuing that money.
Right.
The reason that they did that was, again, because the state can't seem to get its system together when it comes to, dealing out money to landlords, to the Landlord Compensation Fund.
And we know all about that.
Yep. And B, obviously, they're just trying to delay and delay and delay. Basically this self-inflicted gunshot wound of unpaid rent. So that will continue. The grace period will continue. Landlords won't be able to file suit on those amounts until after that time. The Landlord Compensation Fund obviously has its own problems. But obviously, if landlords are exploring that has its own set of circumstances. So again, if that's a route that landlords are trying to go, I'd encourage that. A couple other big ticket items. I mean, obviously in House Bill 4401 right now, and this is now in Senate Bill 282, the first year of occupancy is extended until August 31st of 2021. So if a landlord wants to or had the ability to serve a no-cause notice or a non-renewal of some kind, that option was kind of told. They're going to have the ability to do that after July 30th until kind of August 31st.
So they're not able to do anything until that point.
Yeah, because right now, so think about it this way, kind of using this example. Let's say you entered into a tenancy, with somebody starting on January 1 of 2020, so right before COVID.
Right.
And let's say you had always thought, I'm only going to do this for 1 year. I'm just going to non-renew after that. Well, then obviously COVID hit, and obviously you weren't able to do that then, right? Because throughout COVID, no causes are not allowed. Non-renewals are not allowed. Obviously, you've got your qualifying landlord exemptions. Those are allowed, but you might not have one of those.
Pretty limited scope.
Yep. So that first year of occupancy, you are allowed to serve a no-cause notice pursuant to 90.427. Otherwise, obviously, if you're after the first year of occupancy, then you sort of run into that perpetual tenancy problem. That period of time now is extended. So you have until August 31st, 2021 to do that. Keep in mind, obviously, your local requirements. City of Portland obviously has its own sort of requirements. So where you may be able to serve a 30-day, no cause somewhere else, Portland, Milwaukee, you're still at your 90 days there. So keep that in mind.
Right.
So, a couple other things, balance due notices. With balance due notices under House Bill 4401, they have to contain specific disclosures that eviction for non-payment of rent, charges, or fees is not allowed before a certain time. That language has now been updated. Balance due notices after Senate Bill 282 now need to include a statement that says eviction for non-payment of rent, charges, and fees accrued from April 1, 2020 to June 30th, 2021 is not allowed before February 28th of 2022. So again, I guess the implicit statement there and the thing to take away here is starting July 1, life will go back to a little bit more sense of normalcy. So starting July 1, again, assuming no further legislative or
assuming there's no other executive orders.
Then, if once July 8th rolls around, if no rent is paid for the month of July, you'll be able to serve your non-payment of rent notices.
But you're not able to deal with the balances until February of 2022. So the thought is kind of July 1 thing, there's no other executive orders, things kind of go back to some kind of normal other than what's happened for the last, 18 months, or there's nothing you're doing with that. Okay.
The other thing to keep in mind too with Senate Bill 282 is this has not fully passed the legislature yet.
Right. This is
my
still
understanding.
Right.
Still, I think there's still some ongoing discussions about this. So these sort of things may change a little bit, but I think the general structure is going to be enough of the same where we can talk about it and kind of get an understanding of it.
Okay.
So that's with balance due notices. The couple of changes to some non-payment notices, some required disclosures. It also needs to include that same statement that eviction for non-payment of rent for fees and things like that accrued on or after April 1st, 2020, before June 30th, 2021, not allowed before February 28th, 2022. It also needs to contain a disclosure that information regarding tenant resources is available through a website, www.211info.org, and that's expressly built in there as well. Some changes to tenant reporting and tenant screening. That's also in 282. Landlord may not report to any consumer credit reporting agency a tenant's non-payment of rent, charges, or fees that accrued on or after April 1st, 2020, before July 1st, 2021. So kind of that block of time from start of COVID.
And what do you tell your clients when they get called for references? I mean, I've got tenant A that's moving out and applied for unit over here, and that property owner or the management company calls and says, is there a balance due, or are they? I mean, what do you tell owners and management companies? How do they respond to that to keep them in compliance?
Yeah, under 4401, there wasn't an issue with it. We could do that. And obviously under Senate, under 282, we've got language in here that says when evaluating an applicant, a landlord may not consider an applicant's unpaid rent, including rent reflected in judgments, referrals to debt collection agency that accrued on or after April 1st, 2020 and before March 1st, 2022. So a prospective landlord can't even consider it. So
okay, got it.
They shouldn't even be asking about it. And, when I've had clients, fill out references and things like that, and there was a balance, we would basically, if there was something to disclose, we would disclose it, and we would kind of, put a star by it and say there's a COVID balance, or something along those lines. Never ran into an issue with that, but obviously if it was Senate 282, prospective landlords shouldn't even really be asking about it because they can't consider it. So.
In the theory, if you run a credit check, that balance shouldn't come on there because that shouldn't have been reported to the credit agency anyway.
Yeah, that's and if it is, that's they may run into some problems there.
Yeah.
So again, some of these things are subject to change, but again, it's the main takeaway here is you can tell that the legislature is trying to do something to protect tenants from these balances that have accumulated during COVID. That's the main takeaway here, and that's not going to change. I don't think it's going to, even if this bill goes through some revision, that sort of thing is going to remain the same. The other big thing that is concerning to me is that Senate Bill 282 contains basically changes to how landlords are able to treat non-tenant guests. And so a lot of times what we're dealing with right now is unauthorized occupants, guests staying in excess of time frame set forth in the rental agreement. Basically, a landlord can't enforce a restriction that is based upon the maximum duration of a guest stay in the tenancy. So guests are technically allowed to be there, but if the guest does reside there for more than 15 days in any 12-month period, the landlord is allowed to screen them. So that's positive. And they can require the guest to sign what's called a temporary occupancy agreement, but they can't have the ending date any earlier than February 28th of 2022. So you've effectively, if that tenant wants somebody to be a temporary occupant,
you can't do anything about it.
There's not much you can do about it. They did put in there that it doesn't make this individual a tenant, so that's positive. But again, it's really taking the landlord's ability to kind of control who lives in their premises. It's kind of taking that ability away from them a little bit. So that's concerning as well.
Well, thank you for giving us an update. I'm sure some of this is going to change. As we said, the stuff in Oregon, it seems a little bit further behind in terms of where it is in the legislature. It's not on the governor's desk yet, where the ones we talked about Washington are. So, but as we've said many times when we've had these discussions, Brad, for clients out there and investors, get competent legal advice. The waters are very choppy. It's getting harder and harder. It's like a moving target. Things are changing basically on a weekly, daily basis. So this is not something to go at it alone. We've got Brad's contact if you need that. Again, don't, ask for help, because again, this is stuff that, you're on it nonstop trying to keep abreast of what keeps changing. So
I'm burning the midnight oil, and it's getting to be a struggle.
Yeah, no, I bet. So thank you again for taking the time to do this. I'm sure we'll be talking very soon, and if some of this stuff gets crystallized or doesn't, but we do know for one thing for certain, there will be some changes. But that we can say for sure. So
we'll get some lecture materials and things put together. If anybody needs them, we can certainly distribute them as we have a chance to kind of delve through things a little bit more. But it's so new right now. I've gone through it. I've got a skeletal framework here that I was kind of reading off of. But as I go through, you always notice some things about the law, some things about the language. And so that's kind of where we're at in the process now.
And again, thank you for all the work you do too in Vancouver with trying to, with the various groups to try to get some kind of cooperation together. And, again, at the end of the day, we're all in this together, and, we all want to work together, but it's been difficult the last couple of years in terms of dealing with some of the legislative stuff. So
it's a struggle, but I'm always here. Let me know if you need anything, okay?
We will. Thank you.
We'll see you next time on HFO-TV. Be safe, everybody. Thank you.
Our entire office specializes in multifamily real estate, making HFO the largest multifamily brokerage in the Pacific Northwest. Your success is our passion. Build your legacy with HFO. Call 503-241-5541 or visit our website at hfore.com for more information.